All right, good morning to everyone. Welcome to the Banc Courtroom session of court. I'm honored to be sharing the podium this morning with Judge Dennis from New Orleans and Judge Southwick from Mississippi. We have a full array of cases between now and Wednesday. We have 4 cases for argument this morning. The likelihood we may take a short break between the second and third case. We'll see how it goes. All of you, I know, are veterans of the system, so you know the rules about the lights and so forth. The main thing, though, is just to make sure that you stay in the mic because we do record the proceedings, and so to make sure you're heard. And given the size of the crowd, I take it there are people out there who want to hear the argument as well. So if you keep your voice up, that'll help us. All right, having said that, we call the first case number 22-10511, United States versus Greenlaw et al. Shanmugam, you're first up, sir.
Thank you, Judge Stewart. Shanmugam of Paul Weiss for Appellate Hollis Greenlaw. May it please the court, this was an unusual prosecution, and it was a highly unusual trial. The government filed federal fraud charges against defendants at the instigation of a short seller who was trying to drive down UDF's share price so that he could acquire its assets on the cheap. Yet there was nothing wrong with UDF, and there was nothing criminal about defendants' conduct. UDF returned substantial profits to investors, and it remains a going concern to this day. In the prosecution, the government focused on certain transactions with common borrowers in which UDF advanced funds so that the borrowers could engage in the functional equivalent of refinancing by paying off other loans. All of the relevant aspects of those transactions were fully disclosed. And while the government now disparages those transactions as a Ponzi-like scheme, whatever that means, it has no answer to the undisputed fact that the transactions benefited UDF, its investors, and the borrowers alike. UDF's investors got exactly what they bargained for.
Let me ask you. Well, you're presiding. Go first.
So what I'm going to ask you is, preeminently in your argument, we have a legal issue vis-a-vis the charge or a factual issue or both. In other words, do you need to prevail on the legal issue? If you don't, or you argue as well with sufficiency. So drill in on the legal issue, if that's preeminent, and how you say what the trial judge gave the jury view.
Sure. Let me start with the legal issue and go directly to the instruction, because I think that really highlights the legal problem with the theory as it pertains to the intent. We believe that the relevant intent here is quite straightforward. It's an intent to deprive another of money or property. And in Shaw, the Supreme Court unambiguously held that the federal fraud statutes require an intent to deprive. Now, the government suggests here that an intent to obtain property is sufficient. But the cases on which the government relies really fall into 2 categories. Either cases in which the existence of an intended deprivation was not questioned, and that's the Baker case in particular, or cases where an intent to obtain property was accompanied by a mirror image intent to deprive. And we certainly don't dispute the proposition that in many cases, as in Judd, for instance, those two will go hand in hand. What the government really does in its brief, and it's really quite extraordinary given the length of the government's brief, is to ignore the many appellate decisions that require proof of an intent to deprive. We cite, among others, the Miller case from the 9th Circuit, the Takalov case from the 11th Circuit, and a string of cases from the 2nd Circuit, all of which stand for that proposition. Now, our argument here is twofold. Again, it's easiest to understand the problem with the instruction because it's quite clear, and the government does not dispute, that the relevant instruction requires only an intent to deprive another money or property or to bring about some financial gain to the person engaged in the scheme. And while that is language that was contained in the model jury instruction, that seems to be why Judge O'Connor adopted that language. That language cannot be squared with the relevant case law, and in particular these relatively recent Supreme Court cases, both the Shaw case and the Kelly case, that made clear that an intent to deprive is required.
Counsel, one of the stale defense briefs, I forget where I read it, chastised the government for changing their factual basis. And it does seem to me the government's brief in part is arguing that the financial gain and loss is financial gain to defendants, and the loss is by investors who are enabled by the failure to disclose what's going on. Continue to invest and lose whatever money may have resulted from that. Your reaction to that?
Sure.
Is it a new factual argument, and then what's your reaction?
It is, and the government makes it in two places. It makes it first with regard to the harmlessness of the instructional error, if you agree with us that an intent to deprive is required. And it also makes the argument with regard to sufficiency. So let's talk about the relevant part of the government's brief on harmlessness. It's pages 119 to 109 to 111 of the government's brief. What the government says, and this is its theory as to why the error is harmless, is, quote, the investors were misled into purchasing or maintaining investments in a stock that was not worth what they paid for it. And so their theory here is not simply that it's enough to get someone to invest, because after all, what we have to have is an intent to deprive, not simply an intent to take money in return for an investment of equivalent value. Their theory is now based on tricking people into purchasing a stock that was not worth what they paid for. Now that argument was decidedly not the argument that was made at trial, but beyond that, for purposes of harmlessness, Judge Southwick, there was simply no evidence to support it. In part, ironically, because it was the government that kept out evidence about the stock price, about the value of the investments, precisely because they didn't want the defense to make the point that UDF remains a going concern, remains in good health, and that the investors got precisely what they paid for. Now, if you agree with us that the instruction here was deficient, and I would note that while Judge O'Connor relied on the model jury instruction in trials both before and after this one, he gave the correct instruction. But if you agree with us that there's a legal deficiency here, our submission is simply that we cannot conclude that any error here was harmless beyond a reasonable doubt. Now, I would go further and say that the evidence here was insufficient under the correct legal standard for essentially the same reason, because the government did not present any evidence of an intent to deprive, as that concept is validly understood. And the undisputed evidence that was presented indicated that defendants intended to provide equivalent value to the UDF funds, not that they intended to deprive investors in those funds of money. And that's really the critical point here. I point to the fact that the government refers to this as a Ponzi-like scheme. In an actual Ponzi scheme, what you have is someone inducing someone to invest, knowing that they're investing in something that is insolvent. This is quite to the contrary. This is essentially, as I said at the outset, the functional equivalent of a refinancing transaction. In other words, all that is taking place here is that the borrowers are essentially moving into new loans, generally at better interest rates, and with more substantial collateral for the simple reason that the real estate developments are further along, and therefore there is more there to serve as collateral. That benefits everyone, and it benefits the UDF funds, because the UDF funds get priority liens, and the liens were sort of superior liens in UDF 4 and UDF 5. The collateral was more substantial, and there's no dispute that the loan-to-value ratio was appropriate. These loans were adequately collateralized. And I think what makes this such a strange case is if you look at the offering documents in this case. The offering documents make representations about the loans, but they're representations about the loan-to-value ratio and the like, and there's no claim that there was anything false about that. My friend Mr. Burnham is going to get up in a minute and talk about the false statements in this case. And, of course, our submission to this court is that there were no false statements. But the statements to which the government attaches itself are these remarkably sort of collateral statements about paying distributions from cash from operations, about prohibitions on affiliate transactions. They're not representations about the substance of the loans, what investors were getting. And our fundamental submission about why the conduct at issue here was not criminal is both that there was no intent to steal, but beyond that, that investors got precisely what they bargained for. They invested in certain loans. Those loans were at a certain interest rate, and those loans were fully collateralized and performed. And that's our fundamental submission as to why the conduct here was not criminal.
Well, let me ask you two questions. Number one, the government argues that the instruction given here is identical to what was given in Baker. Is that what you understand your argument to be?
It was materially identical, but the critical point is that this objection was not raised in Baker. The objection that was raised in Baker was that the instruction needed to require an intent to obtain money directly from the victim. And that is the proposition that this court rejected in Baker. We have no trouble with the panels rejecting that proposition
Well,
in Baker.
I get your point, but notwithstanding the objection, if we look at it and the instruction is identical, similar, almost there, and lay it down, does that govern, what we do here? I mean, I understand your point that the objection wasn't made there, but if that's the jury charge that was given and approved by the court, how would the absence of the objection there cure the problem if it's a legal issue?
Sure, Judge Stewart. I think what I would say is that the mere fact that the language was the same doesn't mean that this court's decision should be read sub silentio to reject any and all challenge to that language. It would be quite odd to say that there was an implicit holding in Baker that the instruction was valid even though it didn't require an intent to deprive. And I would note that there was a good reason, I suspect, why the defendant in Baker did not raise the objection that we're raising now. That's because any error in Baker surely would have been harmless. That was a case in which the company at issue had engaged in a paradigmatic fraudulent scheme to send excess products and then report them as legitimate sales. Under that circumstance, the existence of an intent to deprive is obvious. In this case, by contrast, the existence of an intent to deprive is far from obvious. And that's because the government really made no effort at trial to show the existence of such an intent. If you take a look at the testimony of the government's star expert witness, Martinez, he conceded that he did not consider the benefits to UDF investors in conducting his analysis. That's at pages 9358 to 9359 of the record on appeal.
Okay, I have your point then. I know you're on the red light. Don't worry, other side, we got plenty of time. So never fear in terms of like. One last question I have to ask you before I forget. Back to the jury charge conference. Judge O'Connor gave the Fifth Circuit pattern charge, right?
Yes, that's right.
Okay, so at the time of the trial, you've cited in the briefs the 11th Circuit's charge and I think the 9th Circuit and the 4th. But my question is, at the time of the trial and the objection to the Fifth Circuit charge, was Judge O'Connor made aware of what I understand the argument is that the 11th Circuit changed its pattern specifically to deal with the matter which you raised in this case?
I don't recall if the 11th Circuit pattern instruction was specifically drawn to his attention. That this objection was raised at some length. The proposed instruction, which is in 5705, contained the relevant language requiring deprivation of money or property. I would make one other note about this court's case law, because I think the government, frankly, throws up a lot of smoke about this court's case law. I would point in particular to this court's decision in Ratcliffe, which, while it doesn't deal with the same instructional language, makes the very point that we're making here, namely that you have to have an intent to deprive. Merely receiving some benefit is insufficient, and that's the case involving the official who was elected and then was charged with mail fraud for concealing certain campaign finance violations. And this court basically said, well, sure, he's getting paid, but of course that money would be paid to the winning candidate anyway. What is required is something more, an intent to deprive. And Judge Stewart, if you disagreed with me with regard to Baker, I would respectfully submit that I do think that the Supreme Court's directives in this area are quite clear in terms of the existence of an intent to deprive. And we point to the Miller case really as evidence that a sister circuit has so construed the Supreme Court's case law.
All right. I appreciate your responsiveness to my question while we had you there. Anything further? Okay, I know you'll be back up on rebuttal, but I wanted to be clear about the charge. Thank you. All right, we'll hear from
Great, thank you.
Burnham.
Sorry. Good morning, and may it please the court. James Burnham for Kara Obert and Ben Wissink. Judge Stewart, just to answer the question you asked about the district court and the pattern instructions, the same points we make here were made to Judge O'Connor in the district court. In particular, the 11th Circuit, you can see a discussion at ROA 9934. So he was made amply aware of the change. And I do note that even Judge O'Connor seems to have understood we had a point, because in the trials immediately preceding and immediately after our trial, he gave the instruction that we've requested, not the one that he gave at our trial.
How do we know?
Oh, they're in the briefs, Your Honor. We've pulled those instructions for you. I don't know why he did it in the other cases, but if you look in our brief, we have gone and tracked down the instructions he gave and provided them to the court. So those are available for you and your colleagues.
Well, I didn't hear the argument from the person who led off that Kelly in some way, if it didn't change, it at least made even clearer the law in this area post-Baker. And Baker is a problem, it seems to me, our Fifth Circuit opinion. So what do you make of Kelly? Does it alter or clarify or in some way change the law in this area?
Of Kelly, Your Honor?
Yes.
Yeah, so I think Kelly made clear what I think has been
But Kelly's 2020, I think, and Baker's 2019. And
Right.
so I'm just wondering, the argument wasn't perhaps even made in the briefs particularly, but is the argument that whatever we said in Kelly, whatever we said in Baker, we didn't say anything in Kelly, that the Supreme Court has made that clearly wrong?
2 points. I think Baker actually supports us. So if you look at the court's discussion in Baker, they say, quote, the issue is whether the victim's property rights were affected by the misrepresentations. That's a victim-oriented point, deprivation meaning. I think, and I wouldn't presume to tell Your Honor about Baker because I know that Your Honor is very familiar with Baker, but I think it's very clear what
Don't assume anything.
The court in Baker was clear, I think, that our rule is the correct rule. And so in approving of the instruction, all the court was saying is it was an error to not include a separate mirror image requirement that we're not pressing. So that's my first point, is that Baker, I think, actually properly read supports our argument. To the extent the court's not sure about that, I think Kelly dispels any doubt, because Kelly very clearly supports our argument. If I may, though, I'd like to just take one step back from the deprivation issue, because I think it would be helpful for the court to understand just how the business worked. In my view, this is a case where the government has used basically innuendo and confusion to criminalize a completely lawful and successful business. If this strategy and these convictions are allowed to stand, no law-abiding accountant or executive will be safe. To show why, I think it would be helpful to spend just a minute or two on UDF's business model, and then I hope to turn to the falsity issue, which is a purely legal issue, Judge Stewart. One of the points I want to make is we agree with the government on all the basic facts about the business and about the relevant transactions. Our dispute with the government, and it's a vehement one, is about what those facts mean. It is a pure legal question. I'm not asking you to resolve questions of fact. And it has a parallel instructional argument that you can see in the Obert brief that I'll get to if I have time to do so. Here's how it worked. UDF3 would loan money to developers to buy land, raw land, 1,000 acres of land somewhere in Texas. The developers would then spend 25 years turning that land into homes or lots. When UDF3 made these loans, nobody thought, not the investors, not the developers, that those loans to buy the land were going to get repaid 25 years later when the developers sold the lots to the final purchaser. To the contrary, everybody understood that the developers were going to borrow more and more money as the project progressed to pay for continuing the project, and in doing so, to repay the original loan that they used to buy the land. Developers need to use debt to finance their projects this way because they don't get money from buyers until 25 years into the project. The reason that they're able to do it, the reason this business model works, is because as the time goes by, the land becomes more valuable. So it goes from, let's call it $1 an acre, to $100 an acre at time 10. That's because they get approvals, they get entitlements, they add sidewalks, they add sewers, they do all these things. When the land is worth more, it can support a larger loan. And so what the developers do is they take that larger loan to continue to move the project forward, and they repay the old loan. At the same time, the old loan has become over-collateralized. So if UDF3 is given $1,000 to buy 1,000 acres in my hypothetical, and the acres are now worth $100 an acre, you have $100,000 of collateral supporting a $1,000 loan. It doesn't make any sense. The best thing for the developer is to take a new loan for $100,000, pay back the $1,000, and move on. It's these subsequent loans that the government is calling a Ponzi scheme or Ponzi-like scheme or whatever.
But one of the unusual nature from the government's viewpoint of that, maybe the unusual, questionable nature of it, is that the fifth fund had the right under the agreement to sort of force additional distributions over. I mean, I don't know if these are basically an overall value to the loan and there are progress loan payments made along the way. When UDF-5 made a distribution that was not requested by Centurion or the developer, and it went to them, did Centurion or any other developer have any choice in the matter on whether it was paying off the earlier loan? Did any of their money stay with the developer, or did it all go to pay off the earlier loan?
So the answer to both of your questions, the first question is yes, and the second question is...
I don't have the question, so why don't you explain?
Yeah, fair enough, Your Honor. So they absolutely had a choice. So all of the advances, and this is something the government does everything they can to obfuscate, come within an arm's length lending agreement. So the way this works is the developer comes to UDF 4 or 5 and says, I want a $25 million loan. They call it a credit facility, but I'll call it a loan because it's simpler. You don't get the $25 million on day one. So in that sense, it's unlike a mortgage. They don't just give you the cash. What UDF would do is they would give the money as it was needed to move the project forward.
You give money when it wasn't needed is what the government's point.
Right. So let me address your point directly. It was needed because part of the way the project moved forward was freeing up the old collateral. Let me put it like this. The new loan cannot be secured by the collateral, by the land, unless the old loan is paid.
Well, again, that's your model, but the government does have good evidence from emails and otherwise that these payments were coincident with needing to make the distributions to investors at 9.75%.
So two things, Your Honor. I don't dispute that. I'm happy to agree with that, Your Honor. What the government does not have is any evidence that that mattered at all. So I have two very important points I'd like to make on that. The relevant disclosure that that's tethered to is UDF 5's pledge to not engage in affiliate transactions. That is to say, transactions with its corporate affiliates, UDF 3 and UDF 4. There is not any evidence.
Indictments say that. One of the things I think in one of the briefs is that when they add an affiliate in closing argument is one of these developers, did the indictment actually identify affiliates? Did it refer to it?
Oh, yes.
UDF 3, 4, and 4 without saying anything about the developers?
Your Honor, it could not have been more unfair what the prosecutor did in closing argument. The indictment says specifically that the affiliates are the other UDF funds. That's in paragraph 3. They say, quote, will not engage in affiliate transactions with the other fund entities. Paragraph 3, right at the front. The entire case in chief, if Your Honor sits down and reads the transcript, they were prosecuting a case that 5 had transacted with 4 and 3. That was their theory. The problem is they didn't. Every transaction is UDF 5 to a developer, pursuant to a loan agreement, and then a developer sending money to 3. They try to get around this by saying, oh, well, sometimes money went from 5's bank account to 3's bank account, but that doesn't prove anything. When I refinanced my house recently, the lender I refinanced with sent the money to Bank of America, my original lender. That doesn't mean I wasn't a party to the transaction. I'm the one who had the loan agreement with the new lender and the mortgage with the own. That doesn't make any sense. And here's the legal point that I think ties it all together. To sustain these convictions, they had to prove that our accounting judgments were unreasonable accounting judgments. They brought in a disclosure expert at trial, a disclosure expert, to talk about what affiliate transactions mean. You know what that disclosure expert never said? He never said there was any kind of non-entity principle or whatever it is. They have a variety of formulations in their brief that exists in affiliate transactions. He never said that any accountant would understand the term that way. And he never said that even aside from that, he looked at the transactions at all. He said, I have no opinion about whether these transactions are affiliate transactions. That's not the kind of record that can support convictions. If you look at Whiteside, the 11th Circuit's decision discussed in the briefs that underlies this court's decision in Jones, there they threw out false statement convictions because the government's witnesses had testified that the relevant requirement can be, quote, interpreted in different ways, end quote. Here, not only did their evidence not support their sham transaction view in any respect whatsoever, then they're not going to come up and tell you that they have a witness that said that. All the evidence supported our position. To quote one document, Your Honor, then I'd like to make one quick point about the jury instructions, if you'll permit me. There's an independent diligence report in the record, and there's a bunch of witnesses that echo this, from Snyder Kearney Research, or I think it's SK Research. Independent firm, government introduced the document, no suggestion that this is somehow corrupted. It says, in black and white, UDF 5 is, quote, not prohibited from lending to unaffiliated borrowers that are borrowers of prior UDF-sponsored programs. 125, 413. Witness after witness said this was allowed. The closest they got was a few witnesses who said it was a difficult accounting assessment generally on affiliate transactions. So that's my only last point on that. The one other thing I'd like to point out, though, is at a minimum, if the court will permit me, at a minimum, the jury had to decide. We proposed a jury instruction that said a reasonable opinion is not a false statement. The government does not even dispute that that is a correct statement of law. They don't dispute that. All they say is that it was not an important point at the trial, which is a frankly ridiculous argument. The entire trial was about whether the defendants lied. Omitting this instruction made it very difficult to make that point, and the prosecutors capitalized on it aggressively. In closing arguments, around the same time that they were constructively amending the indictment by switching their theory of who the affiliates were, the prosecutor...
We've too many arguments into this. I'm trying to let you get to the end of
Okay, Judge Stewart. Yes, Your Honor. Let me 2 sentences. Here's what the government said. Even if people have different opinions, it can still be false. Look at the definition that Judge O'Connor gave you, or they said read the definition. That's at ROA 10054. This was the very point the jury came to the judge and said they were confused about in deliberations. The failure to give this instruction, one that they agree is a correct statement of law, was extremely debilitating to the defense. Thank you, Your Honor.
All right, thank you. We'll see you back up on rebuttal. All right, Mr. Kobre. How do you pronounce it?
Cobre, thank you, Your Honor. Good morning, Your Honors, and may it please the Court. My name is Elisha Kobre, and I represent Appellant Brandon Jester. Mr. Jester joins in the arguments of his co-defendants. There were no false statements here, and there was no intent to defraud, and the jury instructions on both of those points were incorrect. But there is a distinct and much more fundamental failure of evidence here as to Mr. Jester. Mr. Jester simply did not have knowledge of any of the statements that the government relies on as the basis for the counts of conviction. Each of the counts requires proof that Mr. Jester acted knowingly in making one or more very specific alleged false statements in UDF's SEC filings. But the record here is bare. I'm sorry, Judge. I think it's because of the. Well, let me just
Stop the time for just a moment. Is the microphone rubbing on your?
Yeah, I think it's rubbing a little bit.
Stop the time.
We'll give it a shot. Sorry. I think maybe if you turn it. Is that better, Your Honors?
We don't know.
I'll give it a shot.
I think you lost about 30 seconds.
Well, don't worry. I'll take
Get
care
it
of
back.
it. I'll take care of you.
I appreciate that.
No worries.
But the record is bare of any evidence that Mr. Jester was aware of any of the statements in the SEC filings. In fact, the only evidence in the record is precisely to the contrary, which are the testimony of other asset managers like Mr. Jester that they had no involvement whatsoever, no knowledge of any of the statements in the SEC filings. That is not surprising. Unlike his co-defendants, Mr. Jester was not a C-suite executive at UDF, and he had no involvement in the financial reporting side of the business. He was rather on the property development side with the other asset managers of UDF's business, working with UDF's developers on the land development projects for which UDF was extending loans. There was no reason and no need for him to be involved with the SEC filings.
Counsel, one of the points you make is about the spreadsheets showing and whether it's proper to show future projects on it as well as projects that are already under contract. Allegedly, there had already been an agreement that you say Mr. Jester was unfamiliar with, that this particular document would only show under contract. What evidence was there in the record that the norm is to show, I mean, this was a fair estimate of what was ahead for the business as opposed to just what was under contract?
Yes, Judge. So the evidence on this point was entirely one-sided. A defense expert, Dale Kitchens, testified that there was absolutely no need for there to be an executed contract.
As the usual way these documents are prepared.
That's correct, Your Honor. That's at record 9716. He testified there is nothing in, quote, generally accepted accounting principles or SEC requirements that you must have an executed contract to consider a future project in your cash flow pro formas. Aaron Richards, an asset manager at record 9762. Cash flow pro formas are not certainties and just include projects that you're analyzing that you'd like to acquire. Record at 9812, Jeff Gilpatrick, quote unquote, you do not need to have a project under contract included in future projections.
That's good, Counsel. Tell me what I needed to know.
And I'll just follow that up. That wasn't just witness testimony, Your Honors. There was documentary evidence that was introduced, Defense Exhibit 2120, I believe it was, which was another pro forma, a prior pro forma that included what was listed as new projects 1, 2, 3, and 4. And the reason why they were listed without names is because there were no projects at the time. So the evidence on that point was entirely one-sided. The government relies in trying to scrap together some evidence on Mr. Jester. They point to the transactions that Mr. Jester was involved with. But again, we agree with the co-defendants. There was nothing wrong with those transactions. But more fundamentally, as to Mr. Jester, those transactions, if there was anything wrong with them, it was only related to representations in SEC filings about which Mr. Jester had no knowledge. And there is zero evidence in the record as to that point. And it's important to keep in mind that that goes not only to the conspiracy counts, but there were 8 substantive securities fraud counts which absolutely require knowledge that Mr. Jester knew about these specific representations in SEC filings, and there was nothing in the record whatsoever as to that.
What about the emails that really get more to this, whatever's going to be called Ponzi-like scheme, where Mr. Jester was insisting that certain distributions be made in order to meet the 9.75% investor payments, and he was urging it to be done. How does that implicate your client?
Sure.
Not at all, of course, but why not?
Sure, Your Honor. I mean, it doesn't because, and we don't dispute that evidence and the emails that Mr. Jester was involved in these transactions, again, which we don't think there was anything wrong with. But putting that aside, those transactions are only improper if there was a misrepresentation in SEC filings. The transactions itself were entirely permitted, and the government doesn't dispute this, were entirely permitted by the contracts. They were, and not only that, but they were disclosed in the contracts that those loan advances were entirely proper, and there was nothing improper in using them for distributions once the money came in. In fact, this was all disclosed, in fact, to the auditor, and the government, in fact, cites it in their own brief in an email to Stephanie Brazelin, who was one of the members of the auditing firm, that the government was open, and UDF executives told this to the auditors. They were fully aware of it. I know that my time has expired, but if I can just take one moment to address one point that was, which is the time limitations that were imposed by Judge O'Connor. We acknowledge that this is under a plain error standard, but these were extraordinary time constraints that really created an unfair trial for the defendants here. The defendants here had less than 4 hours to defend a complex securities fraud case. For 4 hours each, that includes cross-examination, direct, and the closest case that even the government can point to this was a case in which each defendant had 12 hours, not 4 hours. And we would submit that that is plain error.
Well,
you allow for that there's huge discretion by the trial court in this arena. This is a, 7-day trial with multiple lawyers, et cetera. So, we get your argument, but that's a pretty big gulf for the district court to kind of portion out the time. But we have the argument.
Thank you, Judge.
Let me ask on that, did anybody suggest a different length of time to Judge O'Connor?
Yes, Your Honor. The defendants suggested a 15-hour per defendant time limitation when the defendants objected.
15 hour?
I'm sorry, 15-hour per defendant.
So 15 hours for all four, you suggested 15 for each.
For each, correct.
Okay, thank you. Sitting from here, it's not hard for me to see how that didn't sell too well. 15 hours would be like this argument. That probably would have expanded from 15 hours per. But anyway, we get your point that you've preserved it.
Sort of like the time limits you're operating under here. They're flexible.
Thank you, Judge.
Exactly. Well, it's a big case, and we'll give everybody a stretch. All right, the government has been patiently waiting. Ms. Burch, you're up. I always like to ask this. Did you try the case or you're on appeal?
Good morning, Your Honor. I did not try this case. The trial lawyer is here with me today.
All right, that's not meant to be at all anything. I just...
No, I appreciate the question. I did try cases for a number of years, so I appreciate the question.
Gotcha. Well, you have the person at the table in case we get a penetrating question. All right, you're on.
Thank you, Your Honor. May it please the court. Amy Burch for the United States. The appellants conspired to and did engage in a lengthy scheme to defraud its investors by making false and misleading statements about the source of payment for UDF-3's distributions and loan payments, and by intentionally reporting that UDF-5 would not engage in affiliate transactions, when in truth...
Clarify from the start in what you're saying. They said, the government said it was like a Ponzi-like scheme. Was that the characterization? And if so, what does that mean in light of what you're sharing now?
Sure, Your Honor. It was a Ponzi-like or Ponzi scheme in that the appellants were taking in the money of later investors to pay off the investments in the earlier funds. And in fact, the district court that presided over the case in one of his post-trial orders actually referred to it also as a Ponzi scheme. I mean, everyone, in terms of how that's been described, that's just the easiest way to make the average person understand what the scheme was.
Isn't that a little dangerous? It's the easiest way to make them think what this scheme is. The definition still needs to fit. And it is certainly not an Allen Stanford. It's not from Mississippi. Unfortunately, it's not a WorldCom was in our territory. It's not a WorldCom situation. And there's real value here. There was collateral for this. Did anybody lose money other than on stock price? And that's evidence, I understand, is not in the evidence? That evidence is not in the record?
Your Honor, there was not evidence at trial about stock price or about losses. What the evidence is that the money was moving from these late...
Okay, but did anybody lose money as it would occur in a Ponzi scheme?
Well, yes, the investors lost money, but
Because of the change in the stock price?
and because of there has to be an inference of understanding here because there wasn't direct evidence presented of this, but the understanding of you're getting an investment in something that isn't what it's purported to be. That is, the later investors are getting a draw on some sort of, are getting a draw on investments that the developers are telling the UDF executives, we don't know if we're ever going to be able to pay off our loans. We're worried. We're concerned. There was evidence that Buffington and Centurion both had expressed these concerns and were essentially blown off. And in the meantime, the UDF executives are insisting on these draws that aren't even going to...
You're sort of drifting into the right to accurate information as opposed to the necessary fraud and taking a property or something of value. Well, if Judge Stewart satisfied, you can move on. We don't need to get wrapped up on this, but I do have doubts that this is properly called a Ponzi scheme.
And the deprivation of property that we've alleged is the deprivation of the investors' money, that by defrauding or engaging in this scheme to defraud the investors were led to put their money into UDF 3, UDF 4, UDF 5. So that's the alleged deprivation.
The other side says the investors actually benefited, and that seems to be where you're at loggerheads. They say that the investors actually benefited from this, so it's different from these other fraud cases where there's actually a loss, property-wise or otherwise. And my question is, you have a forensic accountant, Martinez, I guess his name. I didn't get to read all of his testimony before preparing, but I guess my question is, I understood in the briefing them to say, even in all of his testimony, he didn't take into account in his calculus any loss or deprivation. He just testified in terms of transaction. Is that an accurate characterization?
He testified just as to the movement of the money between the affiliates. He did not testify that as to whether he took into account whether there was any benefit flowing back. That's correct.
So they say if you take what the forensic witness was, you'll understand the flow of the transactions, but they say the transactions were just ordinary course of business. So though the government put that witness on, that doesn't tell the jury or help the government in terms of the falsity, if you will, of it, or this benefit piece. That's where we're struggling with this Ponzi-like characterization here and them saying the benefit. I haven't read as much as you have, but that's pertinent to the question Judge Southwick is asking. Help us understand the falsity or deprivation or whatever. We're going to read it, but to understand from the investor standpoint where this goes off the rails and becomes something other than a bad business transaction versus a crime.
Yes, Your Honor. And the evidence presented at trial was that the investors put their money into these what they're calling going concerns, what the UDF executives say was a benefit to them. But the best summary of what was presented is from what the district court said after trial, and I'm quoting here, the trial evidence showed that the defendants continued to solicit investors, knowing that they were unable to sustain their old investors, quote, and described the, quote, shuffling of funds that occurred in 53 of 60 months' worth of distribution. So in 53 out of 60 months, there wasn't money to pay the distributions.
Let me ask it this way, in a cryptic way. What was the government's smoking gun or smoking guns vis-a-vis testimony? I mean, this is a huge record. We looked at as much as we could. But I mean, if in going straight through, not to miss the other, but what is the evidence we should just absolutely not miss from the standpoint of a witness you have or testimonial that just gets us over the hump of this criminality piece? Do you understand my question?
Right. So UDF 5 board president, Mr. Kahani, testified that the transactions were not brought to his attention. Had he known about those transactions, he would have considered them to be affiliate transactions, and he would not have approved them. There is also, in our brief,
Wouldn't have approved them. That just may mean it was a bad businesses. I mean, still help me get to the criminality.
Well, that they weren't allowed. I mean, there was evidence from auditors that questions were asked, they couldn't get their questions answered. There was a later auditor that testified that he was trying to do due diligence, asked questions about related transactions, and he got shut down. There was lots of evidence of email traffic of on the day distributions are due, let's just send this through. We'll figure it out later. We'll figure out where we're going to draw from later. On one occasion, it wasn't even closed where they were saying later, we're going to figure out how to fund this. And so
This may be more of a question for the other side, but you know what the record is. The 53 out of 60, how much of that is timing that this distribution to investors would do at a certain day of the month, I guess, or date? Is there any evidence that later in that same month or time period before the next distribution is due, that additional money came in? It was really more of a timing thing than the total, the Ponzi-like character of it that you want to keep
Your Honor,
focusing us on?
it's not a timing thing.
Well, what's the evidence? I mean, is there no
Yes,
evidence to show that
Government
it's a timing
exhibits
thing?
4, 10, 11, 12, and 13 are summary exhibits that show how the money was transferred and how it funded each of those exhibits. So the timing was scramble, 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 and we'll take it from a draw. Again, with these investors having specifically said, would you please quit doing this? I mean, not the investors, I misspoke, the developers saying, please quit doing this. They're drawing from them without their being able to direct, no, I need money on this project, not that project. UDF was deciding which money to draw the projects on. UDF was the one telling them who, when, and where those draws were going to take place. And on one occasion, they had one of the funds send to the penny an amount into the other fund and say, now send it right back the same day. Why do you need to do that if it's all on the up and up? It was not on the up and up. There was this mad dash at the time investments were due because UDF 3 couldn't pay them to go into 4 and 5 and take those investors' money to make those distributions to UDF.
But it still has to be criminal. I mean, I think you had it in bold, the 04 or whatever it was, the .04, the penny distribution, so we would not miss it in your brief. But it does seem to me that it still has to be criminal. And what I'm hearing from the other side, or maybe not heard so much, is read in the briefs, is all this was authorized by agreements that were disclosed. There was nothing secretive about this. This, again, is not Allen Stanford or WorldCom. What about the fact that what they're doing was authorized by disclosed agreements?
Your Honor, what they are doing was...
We're doing.
I mean,
I misspoke.
I understand, Your Honor. And I also want to, we've had these long conversations about what the facts show or don't show. I mean, obviously, at this point, we are taking all the facts in the light most favorable to the verdict with all the reasonable inferences drawn therefrom. The jury was instructed on the fact that they had to find criminal intent, and they found it. And this court's case law says that that jury finding is entitled to deference when intent has to be inferred from the facts and circumstances. And so certainly here I understand your question, but in answering it, I'd like to reorient that we are not having a first-time discussions of the facts here.
Well, that's true, and we don't want to derail you, but you know as well as we do, the government has the burden of proof.
Absolutely.
Beyond a reasonable doubt. And so we're just trying to be clear, not taking either side, but just to understand the gravamen of the criminal piece, not just a whole flow of transactions.
Right.
And they say, well, I think the lead-off statement, we agree on the facts. So all the transactions just seem not to be, quote, factually disputed. That's what we're trying to get a clear picture. Maybe this will circle you back within the facts you just described, back to the earlier pieces about the jury charge. In other words, what the indictment alleged and how the facts, as you just helped us with, fit into the dispute about the jury charge and whether that's sufficient, Kelly, Baker, and so forth.
Yes, Your Honor. And so to finish the answer to your question, yes, the facts show by way of the timing in those emails that are cited in our brief, I think it's pages 56 and 57, and then again in the 70s pages, there are bullet points that show what those emails show and the timing of those emails, and how there's not even concern about whether collateralized, and in one it wasn't even a done deal, and we're calling that the benefit that the other investors supposedly got. But to get back to the question about the jury instructions, the appellants are asking this court to find error in its own 2019 pattern instruction that defines a scheme to defraud is any plan, pattern, course, or action intended to deprive another of money or property or bring about a financial gain or scheme. And as we talked about in Baker, this court has approved of that specific jury charge, and I would ask the court to take the time. I know it's a very long record, but there's a short part of the jury conference, the jury charge conference, where Judge O'Connor is sort of pressing at that, and it's on 9922 of the record where they start talking about the instruction. And Judge O'Connor is listening to them about these cases and ultimately comes to the conclusion, look, there really hasn't been anything that tells me that there's some reason that I should not give the pattern instruction here. And although the appellants rely on Shaw is not an intervening case of Supreme Court. It's a 2016 case. It predates this court's 2019 instruction. And even though Kelly came later, it is post-Baker, Kelly deals with what is property. Not that there has to be a property deprivation, but what is property. And so that has
What do you mean? I mean, Kelly does say there needs to be a deceit with the intent to take money or property.
Exactly. And that's
So
what
here,
we have
the
here.
jury instruction allowed just financial gain was sufficient, even if you're not taking money or property from somebody by deceit. Did that come up in the jury conference? What did O'Connor do with that distinction? Well, it doesn't matter. What do you do with that distinction?
Well, what we do in this case is say exactly what my opponents were saying, is it's two sides of the same coin. And they say in most cases that's the case. It's not the case here. But in this case, it is the same thing.
So it means it's harmless. Is that where you're headed with that?
Absolutely.
It's not the same legal statement. I mean, it's the opposite of it. And sometimes there won't be any intent to take money or property, but there's still going to be a financial gain. And so it seems to me at best that argument is that it's wrong but harmless. The instruction was error but harmless.
I don't believe it's a wrong instruction, but even if the court were to determine it's a wrong instruction, it is harmless because the theory of prosecution has always been the intent to deprive those investors of their property, that is their money.
What do you say, maybe I misunderstood, and I think it's in the briefing, reply briefs, and as well as at argument today, that wasn't the position of the government at district court. Did I misunderstand their statement? And if I didn't, what do you make of it?
Yes, so there's been multiple iterations of the government has changed its theory, the government's changed its mind, but if you go back from the indictment and you walk all the way through, the theory of prosecution has always been that there was an intent to deprive these investors of their money, to obtain their money by means of false, fraudulent misrepresentations, the false statements that are in those SEC filings. And that was what the evidence presented was. That's what the arguments made to the jury was. That is what Judge O'Connor found before and after the trial. And the instructions that the court gave on good faith should really help this court deal with some of the appellants' concerns that the jury somehow convicted them for something that wasn't illegal, because the district court specifically told the jury that it could consider whether or not the defendant had a good faith belief that what he or she was doing was legal, and if you have a reasonable doubt as to whether or not the defendant had a good faith belief that what he or she was doing was legal, you must acquit. And so there was always evidence of the intent to deprive. They put on plenty of evidence about what the auditors thought or didn't think. They crossed Martinez extensively on what they allege is some sort of failure to explain why there was no benefit. But at the end of the day, the jury got the evidence, and the jury was instructed that they must acquit if they had any reasonable doubt that these four appellants were operating on some sort of good faith belief that what they were doing was okay. Your Honor, I want to take...
While you're still on the charge, what's your response to counsel opposite's arguments about the contrary jury charges, the 11th Circuit and some others, but specifically their argument that, I guess they have it in their brief for the record, some change that Judge O'Connor made?
So the 11th Circuit has a 2020 pattern instruction, and it describes a scheme to defraud as a plan or course of action that's intended to deceive or cheat someone out of their money or property by using a false or fraudulent pretense, representation, or promise. And so even under that definition from the 11th Circuit, the government's evidence would be sufficient here to establish the scheme to defraud and the scheme to deprive investors of their money.
I'm not sure why that would matter, that your evidence was sufficient. That's not the charge the jury got. They got this extra language. And so the problem is the extra language.
Well, and I...
So I guess all I'm saying, I don't quite understand your point.
Yeah.
11th, I mean, I think I dare to say, to assume an attorney would be happy with anything, but I'm guessing they would have been happy with that instruction insofar as their present position is concerned. And so, anyway. Now, has Judge O'Connor himself changed his instruction?
I'm sorry, can you say
Has Judge O'Connor used a different instruction in other cases? That's not part of what's been developed in the briefing? I'm trying to understand what the opposing counsel said earlier. Has Judge O'Connor himself used in any kind of wire fraud case a different instruction than this one?
Oh, there was an earlier instruction that he gave prior to this pattern. He gave an old pattern instruction in another case. And then in a subsequent case, and that case is a very unusual case. It's related to the Boeing airplane issues. And so that case he did give a different instruction subsequently. But for this case, after carefully considering the instructions, he came to the conclusion, based on this court's case law, that was an appropriate instruction, and we believe he's right, but even if he's wrong, we're thrown back to harmlessness, and that was my only point about the 11th Circuit instruction, was if what they're wanting to say is, hey, we should do what the 11th Circuit did, we would prevail even under the 11th Circuit instruction. Your Honor, I'd like to take a moment on the time limits. This court applies an abuse of discretion standard to that. The touchstone of that is reasonableness. I haven't been able to find a case in this circuit that warranted reversal based on time limits. And I'd like to point the court's attention to record site 7737. That's Judge O'Connor's post-trial ruling related to time. And he says that he would have considered giving more time if anyone had asked. There was no record made of what the defendants or appellants would have done with more time, and that it was his view that the appellants were trying to use the time limit as both shield and sword. That is, that they intentionally misled the court about what appellants would testify, hoping that the government would run out of time, and that they would then have the benefit of the time limit. And so, based on at least the district court's observation, along with the failure to preserve that issue, we would say that the time limit did not amount to an abuse of discretion.
It does seem to me it's an important question, as some of the briefing indicated. It's a growing, perhaps, approach, or at least consideration by some district courts. Did Judge O'Connor give any indication of how he came up with that number?
He did not indicate how he came up with that number.
I mean, looking at the size of the case, the complexity of the facts, number of parties, it's an interesting short time frame that he came up with.
Understood, Your Honor, and it certainly did require the government to get all its ducks in a row, and as Judge O'Connor noted, that, time limits are typically harder on the government, who carries the burden of proof, than on anyone else.
That may not have been true here.
Your Honor, I believe I touched on this, but because the appellants touched on it when they spoke, there was argument about whether the government constructively amended the indictment by referring to the affiliate transactions. And I would just point the court to the actual indictment. The indictment was that UDF 5 engaged in affiliate transactions by issuing loans to developers that previously had loans with Fund 3 and 4, and the Fund 5 loans were used to repay the loans previously issued. And that presentation in the indictment is wholly consistent with the argument the government made in closing. And a constructive amendment only occurs when it permits the defendant to be convicted on a factual basis that essentially modifies an essential element of the offense or permits the government to convict a defendant on a materially different theory or set of facts than with what he or she was charged. And so for that reason, because the arguments the prosecutor made in closing were reasonable inferences from the evidence presented at trial, that being that essentially UDF controlled both sides of every draw that happened, and that those draws were not coming out to benefit the developer. In fact, there was a Blake Buffington testified that at a time when Buffington was really struggling and needed some overhead, the appellants were taking draws to make their UDF 3 distributions. And so, at least related to that, there was no constructive amendment of the indictment in any respect.
Counsel, it seems to me a significant question. I'd hate to think one sentence maybe is to, in a closing argument, have dramatic impact. I'm looking at paragraph 3 in the indictment, and the only thing it refers to, after referring to affiliate transactions, that the funds agreed not to engage in them, it names the other funds or all the funds. You're saying that the evidence sort of at trial generated this additional way to view what happened. But it seems to me indictment is still there, and this indictment is still limited to the funds themselves being the affiliates. So help me with that. I do think this is a quite significant point, because one way to look at the evidence is that there was no evidence that they were engaged in transactions with Funds 3 and 4, that Fund 5 was. And you really do need us to look at this, or the jury to look at it in terms of these developers. I mean, do you have any case that sort of says that this sort of elaboration on the indictment can come from the evidence that's introduced as opposed to you needing to amend the indictment?
Well, respectfully, Your Honor, I don't believe that. Although the indictment, the indictment talked about the specific transactions and so alleged those transactions, and then to your statement that there was no evidence that 5 engaged.
If we decide that the evidence isn't there, and you need that the affiliate transactions were with Buffington or Centurion, I'm hung up on the indictment doesn't refer to that. So just posit that that's where that I come out that way on the evidence. So where are we on the indictment not referring to them being affiliates?
We're still okay under Reeser because that's not a material or substantially different set of facts. And also, to the extent that I understand you're saying if we come out that way on the evidence, but there was evidence of at least one direct transaction that didn't go through Buffington or Centurion from 5 to 3, and those are you can see that in the summary exhibit, I think it's 412, government exhibit 412, where it lays out where the money's moved. So there are times when it hits, there are times when it hits an affiliate and then gets sent right back.
But only one time directly.
There's at least one time where there's a direct transfer from 5 to 3, which is unquestionably an affiliate transaction.
And enough for all these years in prison?
Well, yes, enough for all these years in prison for people that lied on the SEC filings, conspired with one another to defraud the investors, and certainly we've listed out all of the evidence in our brief, but there was evidence from Buffington that they asked them to stop. There was evidence from about Mr. Jester and Mr. Wissink directing these changes in the spreadsheet to show projects paying off that weren't actually paying off, knowing that the outside auditors are going to rely on that. Beyond Buffington, Centurion CFO Casey Ford had concerns that Centurion wouldn't pay off, and Tyson Walker, a UDF asset manager, told Mr. Greenlaw, Mr. Wissink, and Mr. Jester about his concerns, and they were unconcerned. There were times where he said, look, they would joke about stonewalling the auditors. And so there was a lot of testimony that the jury could use to understand that the scheme that was happening, and despite all of this, the fact that that 9.75 return on the investment was being touted to pull in these UDF-5 investors when they chose to say they were the ones that weren't going to engage in affiliate transactions. Why? Because there was lots of testimony that affiliate transactions were in disfavor, and that would be lifeblood for new investors. And I just have a few seconds, but I want to leave the court with these words from Judge O'Connor after he found a $100 million intended loss.
Hold up, I was
Yes.
prepared to give you some additional time because I had stretched them out, so I don't want you to rush. I can give you some additional time. Madam Clerk, give her an additional 4 minutes. I mean, we stretched them out on the other side. I mean, you got to deal with all of them, so I don't want you to be cut short.
You don't have to take the time.
I
You don't have to
appreciate
take it, but I do want to be even-handed to not make you rush through something important to say.
Thank you. I appreciate that very much. There were the UDF-5 board member, Mr. Kahani, testified that he would have considered those to be affiliate transactions. He would not have approved them. There was evidence from at least 2 different banks that UDF-3 was unable or unwilling to make its loan payments on time. That was the legacy loan that ultimately a different fund ended up paying, and Independence Bank that talked about how UDF-5 was delaying its payments and they were going to start separating. And that is just a small part of the evidence that the jury heard, and that the district court heard. And the district court, being asked multiple times after the trial to consider the verdict, consider losses, the district court found at least an intended loss of $100 million, and it said this, quote, "The investment model was doomed, yet defendants continued to funnel investors' money into a condemned scheme that would crumble unless caught. They knew they were recruiting investors into an unsustainable scheme, all while hiding its instability from investors and waiting for it to collapse, which was more than enough evidence to show their intent." And I submit to the court that the 12 people in the box who heard the evidence came to the right conclusion. The district court that presided over the trial and heard and saw the evidence, every single person that testified, all of the exhibits, came to the same conclusion. And for those reasons, the government asked this court to affirm the jury verdict.
Let me get you to use a little bit more of your time. No restitution was ordered in this case?
That's correct.
Why was that?
There wasn't a wholesome explanation. I can give you
Ultimate what?
our belief of why there was no restitution ordered. And our belief that there was no restitution ordered is because the complexity of figuring out what the loss to each individual investor. It can't just be, hey, I know there's a loss of $100 million, click, because it's restitution and not just loss. It has to be penny exact to every single investor. And because we had intervening things here, we had the defendant's scheme. We did have the short sale with Kyle Bass. You have later investor lawsuits against the UDF entities where there are negotiations and recoveries and all of these other things that are all happening outside of this record. And again, I would submit, although there's this argument that this is this ongoing, wonderful place, I mean, that again is outside the record, but we disagree with the assessment of this as a healthy event.
It government argue for restitution?
The government did submit, I think in the PSR part for restitution, but the court entered an order basically saying that it was not going to order restitution.
What was the government's argument for restitution? It had calculated some amount?
Yeah, so we had some difficulty with restitution because of the voluminous nature of getting all of these people. We put out a bulletin to try to get the investors to submit their information. We came up with a number that we thought was fair and right, and in the end, it seems, at least in our view, that the district court just ultimately thought that trying to figure out the penny amount to each investor of the loss.
Just trying to understand the thrust of that. I mean, we get plenty of huge cases with jillions of dollars
Yeah.
worth of restitution, and nobody says they're incalculable as a reason not to order it. I'm not talking about the trial judge, but trying to get my head around and back to this starting point about loss, deprivation, et cetera,
Understood.
You see what I'm saying? So, I mean,
Yes.
we get plenty of cases where, I mean, the losses are way up there in the stratosphere, but somebody puts pen to say it's at least this or that or whatever, or we look in the record and there are investors saying, well, we lost so and so. That kind of gives us a trail, if you will, to whether you had to prove it or not, the loss, the deprivation. But for me, it just clouds it up again to their argument. Well, the reason there wasn't any restitution because there was no loss, there was no deprivation, et cetera, et cetera. Now, we're not trying to get in the trial judge's head, but that's why I was asking if the government asked for restitution, and if so, what it's...
In the materials that we submitted for the preparation of the pre-sentence report, we did ask for restitution. We do believe that restitution would have been appropriate, and we do believe that the district court's finding related to intended loss is appropriate and, did not further continue to pursue restitution in light of all the other issues.
Last question on that. So within the trial evidence, which we'll look at, is there investor testimony by one, some, or many that as part of their testimony, they testify to loss or what might otherwise be?
To the best of my recollections, we did not call any of the investors because at that point we were not required to prove any kind of loss. We did call investment brokers and security brokers who testified that they did not know that these transactions were taking place based on the SEC filings, and had they known, they would not have recommended these investments, which is different than somebody saying, I lost X amount of money. There was nobody that testified about that.
Okay. All right. Well, just trying to understand. I mean, if the argument is they say there was a benefit and all this sort of stuff, just look like,
No.
Some investors saying, no, this wasn't a benefit, I actually lost, helps a 12-person lay jury understand all these complicated numbers, but particularly the government's, theory. So we're going to look at the record in all its complexity. We just want to know what to be, scouring through. But
Understood, Your Honor, and that's why I pointed the court to the intended loss finding, because it's the closest thing we have in the record to what was the actual loss amount.
Okay. All right. Well, we certainly appreciate your responses to our questions.
Thank you.
Thank you. All right. We're back on rebuttal.
Thank you, Judge Stewart. Judge Southwick asked whether any investors lost money. Ms. Burch has conceded now twice that there was no such evidence at trial. No investors even testified at trial. For purposes of harmlessness, that's the end of the inquiry. Now, to be sure, at sentencing, the government made some effort to show loss. But, as Judge Southwick noted, Judge O'Connor conspicuously refused to order restitution for any loss to anyone, and this $100 million intended loss figure is simply the total amount of the advances that were made. It bears no correlation to any loss suffered by any actual investor. So I would submit that there was far from any smoking gun here, not even a lukewarm slingshot of evidence on this issue. Now, the straightest line to a reversal here, in our view, is on the instructional error with regard to an intent to defraud. And let me directly address Judge Southwick's questions about the cases, and in particular, Baker and Kelly. Kelly, in our view, confirms that an intent to deprive is required. And in addition to the language that you read Judge Southwick to my friend Ms. Burch, I would point the court to page 1571, where the court said that conduct is criminal only if there is, quote, a deceptive scheme to deprive the victim of money or property. And in Kelly, if personal gain had been sufficient, there would have been personal gain for the simple reason that the defendants received salaries even in the wake of the bridge scandal. Now, as to Baker, Baker, again, did not specifically address this issue, but if anything, as Mr. Burnham noted, Baker contains language supporting our view, and I would point to page 405, where the court concluded that there was sufficient evidence that, quote, the scheme affected the victim's property rights by wrongfully leaving them without money that they otherwise would have possessed. Now, why does this error matter? The original jury could have concluded that simply because defendants drew salaries, they possessed an intent to obtain personal gain. Indeed, that was the only evidence that the government presented on intent. This was not a mirror image case because the defendants obviously did not abscond with the investors' funds, as is the case in a paradigmatic fraud case. And the defendants, at a minimum in our view, should have the opportunity to have a new trial and potentially to have a different outcome under correct instructions. This case is plainly at the edges of the federal fraud statutes. The government must show an intent to deprive, and here that requires the government to show that defendants took money without providing something of equivalent value. We don't believe that the government has done so, and we don't believe that the government could do so. And so regardless whether the court looks at the sufficiency of the evidence at the trial or at the instructions here, the court should either reverse or vacate the convictions.
All right, thank you, sir.
Thank you, Your Honors.
Burnham?
Thank you, Your Honors. To start, my friend's smoking gun evidence. The smoking gun was board member Kahane, who she said testified these transactions did not come to his attention and he would not have approved them. That is completely false. Go read his testimony. What he said is that hypothetical transactions that the prosecutor crafted that did not include common borrowers could have been a problem, but he clarified on cross that they never asked him about common borrowers. But if that's not enough, not only is that what he said, he approved one of the challenged transactions. He approved it. It's in the record. It's at ROA, I misplaced the site, but it's at ROA 113412. Their smoking gun witness approved one of the challenged transactions. That is our smoking gun, not theirs. My colleague kept saying that UDF-5 had affiliate transactions with Buffington. UDF-5 had 0 transactions that involved Buffington. Buffington drops off the face of the case after UDF-4. If the government can't even keep straight who had transactions with who, how is the jury supposed to do that? We've talked about Ponzi schemes. Not only did they not prove any losses, there's not a single person who testified at trial that the defendants told a lie. Not one. I promised the Madoff trial was filled with investors who said they were lied to. This trial has 0. They didn't call a single investor, nobody else. On the timing, no witness testified that the timing of the the advances, was relevant to the accounting treatment of these transactions as affiliate or whether it's cash from operations. There's not a single witness that suggested their Hail Mary in closing argument that an independently owned and operated developer could somehow become a corporate affiliate within the context of a particular loan agreement. There's nothing to support it, which is why they didn't charge it that way and why they haven't argued it that way on appeal. Nor did any witness suggest that these transactions lacked value in any respect. If I could just make one more point. Your Honors, we have 4 innocent people sitting in prison right now. They've been there since June, and I respectfully submit that the voluminous briefing in this case and today's argument demonstrates that there is at least one fairly debatable question of law underlying the convictions. That is all we have to show to obtain release. The defendants were free during the proceedings below, and there is no dispute they meet the other requirements. We thus respectfully ask that the court grant them release so they can be with their families while the court considers this extremely complex appeal, much as the court did over the summer in the Hamilton case, which I know Judge Southwick is somewhat familiar with. Thank you, Your Honors.
The government entirely failed to address the arguments that we make as to Mr. Jester, and there are 2 critical points that they failed to address in their brief and they failed to address today, and which were totally lacking at trial. That is, number one, there was no evidence whatsoever presented to the jury that Mr. Jester had any knowledge of the critical representations that the government relied on at trial. And they failed to address that. The evidence is entirely to the contrary. Asset managers testified that they had no knowledge of those representations in the SEC filings. Again, there was nothing false about them, as my colleagues have argued, but Mr. Jester had no knowledge of them whatsoever. Second point they failed to address, the spreadsheet, as I answered in response to Judge Southwick's questions before, the evidence is entirely one-sided. There is no evidence to the contrary. There was nothing improper about that spreadsheet. The pro formas included a variety of types of projects, including projects that had not reached the execution stage.
Let me ask you about that. There's at least one spreadsheet, 1 month, I guess, in which the initial spreadsheet pro forma wasn't robust enough, and your client said, add all these other things to it. Maybe that happened several times, but is that an actual event, and what can you tell me about that? It seems to me that at least it could infer from that Mr. Jester knew more about what was going on than you are indicating.
I don't think so, Your Honor, because the testimony, again, was entirely one-sided. That this is a business plan and that it did not need to include executed contracts. And in fact,
But he did insist on adding considerably more projects to at least one of these. Is that correct?
As part of the business plan, at the direction of his supervisor, yes, he did that. But again, there was no evidence that there was anything improper about that whatsoever.
Understood.
In fact, the spreadsheet, as it came to UDF from Buffington, already included projects that had not reached an executed contract stage. So there was nothing to suggest, and I would just point this court to the decisions of Nganji and in Nora. It is not sufficient. The government simply may not rely on conjecture, or they may not rely upon an inference, and may not, as in Mr. Jester's case, rely upon he should have known or proximity. This is entirely insufficient, and we ask the court to reverse Mr. Jester's convictions.
All right. Thank you, sir. All right, court. Close the arguments in this case. The court appreciates the briefing and robust argument from both sides. We will get it decided as best we can as soon as.